Bill 5536. A substitute is in order. Second substitute is in order. Senator Robinson.
Thank you, Mr. President. I move that second substitute Senate Bill 5536 be substituted for Senate Bill 5536 and that second substitute Senate Bill 5536 be placed on today's second reading calendar.
Senator Robinson moves that second substitute Senate Bill 5536 be substituted for Senate Bill 5536 and that second substitute Senate Bill 5536 take its place on today's second reading calendar. Hearing no objection, so ordered. Second substitute Senate Bill 5536, the Secretary will read.
An act relating to justice system and behavioral health responses for persons experiencing circumstances that involve controlled substances.
Last line.
Institutions and take effect July 1st, 2023.
Amendment at the desk, amendment number 0094. The Secretary will read.
Beginning on page 14, line 28, strike all of subsection 9, renumber the remaining subsections consecutively, and correct any internal references accordingly.
Senator Nguyen.
Thank you so much, Mr. President. I'd like to withdraw this amendment.
Senator Nguyen withdraws Amendment 94 without objection, so ordered. Further amendment, amendment number 0079, the Secretary will read.
On page 36, after line 34, insert the following.
Last line.
Effective date and insert effective dates.
Senator Mullet.
Thank you, Mr. President. I'd like to withdraw this amendment.
Without objection, amendment number 0079 is withdrawn. Further amendments? Amendment number 0154, the Secretary will read.
Strike everything after the enacting clause and insert the following. New section, section 1. The legislature finds that substance use disorders.
Last line.
Date and declaring an emergency.
Senator Robinson.
Thank you, Mr. President. I'd like to move the striking amendment number 154.
Senator Robinson moves striking amendment number 0154 be adopted. Amendments to the amendment. Amendment number 0172, the Secretary will read. Yeah. 162. Yeah. I did? No, I said 162. Okay. I said 0162. The Secretary will read amendment number 0162.
On page 6, after line 22, insert the following. New section, section
Last
6.
line.
On page 36, line 22, after 69.41.030, insert 9.948.518.
Senator Padden.
Mr. President, I think my hearing's pretty good. I'll move to adopt Amendment 0162.
Senator Padden moves to adopt amendment number 0162. Remarks, Senator Padden.
Thank you, Mr. President. We know that the Blake decision came down February 25th, 2001. During that decision by our Supreme Court in a 5-4 decision, they struck down our felony drug possession law as unconstitutional, but not because it was a felony. In fact, the felony had nothing to do with it whatsoever. It was because knowingly was not part of the legislation. So there was never a problem with the court with the idea of a felony. So what this amendment deals with is not the same that the bill I introduced, which was a felony for any hard drugs. This is a felony limited to fentanyl. And fentanyl is a scourge in our country right now and in our state. Last year, there were over 107,375 deaths from overdoses, drug overdoses. 67% of them, 2/3, were from fentanyl or other synthetic opioids. So it's an extremely serious problem. And to bring it down to a more human level, we had testimony of a lady that I've met, Molly Kane, who testified before Congress, who lost her son to a drug overdose from fentanyl. And these stories are all too common. You know, the promise of a life ahead that's taken from us way too soon and so needlessly. We know that there have been record deaths of synthetic opioids throughout our state. And for the Molly Keynes of this world, we need to do something. And law enforcement tells me, Mr. President, that they've got to have leverage to get people into treatment and also to hold them accountable. I mean, I'm all for treatment for people that can get themselves into treatment or want to have treatment and helping them out to get treatment. But sad to say, there are some people who will not get treatment and instead will continue to commit crimes that are so out of control in our state. Told the story about the daycare center in downtown Spokane that has had people using fentanyl, and the little kids can see through the windows that they're doing it, or the people that have set a couch on fire. And we've seen, as a result of all the crime down there, we see people leaving, businesses leaving. The occupancy rate in downtown commercial buildings is going down because of this, and fentanyl is a key. In addition, Mr. President, and while drug courts can take somebody that might have a possession charge and another felony, but if they just have a possession charge, they just have fentanyl, and they want to go through the drug court, it needs to be a felony right now. Now, that might be changed, but right now, it needs to be a felony. And if it is changed, there's going to be a transition period that's going to be very difficult because the judicial infrastructure is set in Superior Court, which handles felonies. The district court maybe can handle some of it. Municipal courts is going to be far more difficult. So I ask you to support this legislation. I think it's quite modest, and I think the crisis that we have with fentanyl in our state cries out that it be a felony. So urge your support. Thank you very much, Mr. President.
Further remarks, Senator Dhingra.
Thank you, Mr. President. I unfortunately rise in opposition to this amendment. Absolutely. Fentanyl is really responsible for so many of the overdose deaths we've been seeing in the state and in this country. It is so potent that when people take it just once, they overdose and die. And so the issue really is not about what do you do with someone who's in possession of fentanyl, because these individuals are dying. The question really is about how do we come up with a state drug policy. People don't go out and buy fentanyl to do drugs. Fentanyl is mixed into drugs. And the logistical issue with this amendment is supposing an individual is caught with 5 pills. One of the pills has fentanyl, the others don't. It creates a very confusing situation where are you then going to be charging them for a misdemeanor for 3 pills, but 1 felony for 1 pill? It just sets up a very challenging structure. There are a lot of other great bills, a lot of other great policies that we're working on this session to address fentanyl. We passed an excellent bill off of this floor that dealt with endangering others if they are exposed to fentanyl. And, you know, I think that was clear to unanimous off this floor because we want to make sure we are preventing those individuals from coming into spaces where they may be exposed to fentanyl. We have another great bill about testing to make sure people can test whether or not there is fentanyl in their drugs. Because as we know, people don't go out and buy fentanyl. It is mixed into the drug products that they are consuming. And that's the reason why I'm going to say a no on this amendment, because it is not simply as simple as possession of fentanyl. We will be having a discussion later on the use of pill presses. How can we take a look at that to address a fentanyl crisis? And I am really sorry to report, but there are 2 new synthetic drugs coming into our state that our law enforcement officers are seeing on the street now that are more potent, if not the same amount as fentanyls. And so we have to have a drug policy that is consistent, because I can guarantee you that every few months, every few years, there's going to be something new. I remember the meth crisis. I prosecuted meth labs. Not a fun case to prosecute, let me tell you. And now it's fentanyl. Next year, it's going to be something else, and the year after that's going to be something else. And so I understand the sentiment. I understand the tragedy of lives lost, but this is not the amendment to fix that. So I'm going to ask for a no vote.
Further remarks, Senator Padden.
Thank you, Mr. President. Would just indicate that I have faith in our prosecutors having discretion to make the decision as to what to prosecute and to determine how they have it all the time. They might have some crimes that are misdemeanor, some are felonies, and they can handle that. And they have handled it. So I think that is something that is not going to be a problem. And to say there's new, more powerful drugs coming, so we shouldn't make fentanyl a felony, I think misses the point. We got to deal with whatever is out there. And if we need to make changes in the future and change our laws, we have to do that to address what the problem is. And we don't have a great success here. I mean, the bill that passed in 2021, I mean, everybody admits has not worked. And that's being kind to say it that way. And it basically decriminalized hard drugs, at least on the first 2 times. And there have been almost 0 misdemeanors that have been prosecuted. There was no way for law enforcement to communicate with each other to even know how many times it is. So I think this is a way, again, to help people get treatment. And if they get in the drug court and get treatment, they're not going to have this on their record. So I again would urge the body's support for this amendment. Thank you.
Further remarks? If there are no further remarks, the question before the Senate is the motion to adopt Amendment 0162. Remote members are reminded to please raise your hand to indicate your vote. All those in favor of the amendment signify by saying aye. Opposed, no. The noes appear to have it. Division's been called for. Will the aye votes please stand, remain standing without motion until instructed otherwise? Be seated. Opposed, please stand, remain standing without motion. The noes have it. The amendment is not adopted. Further amendments? Further amendments? Amendment number 0157, the Secretary will read.
On page 9, line 30, after section, strike and. On page 9, line 35, after program, insert and.
Last line.
Internal references accordingly.
Senator Dhingra.
Thank you, Mr. President. I move adoption of Amendment 0157.
Senator Dhingra moves adoption of amendment number 0157. Remarks, Senator Dhingra.
Thank you, Mr. President. Mr. President, in order for a plea of guilty to be valid, the prosecutor has to basically say in open court that they believe that the plea is made knowingly, voluntarily, and intelligently, which means that the individual who's pleading guilty has been advised of all the rights that they are giving up in order to plead guilty. The court has to then make a colloquy to ensure that the defendant understands that, again, that the plea is made knowingly, voluntarily, intelligently, and that again means that they understand the rights they're giving up. What this amendment does is it ensures that the defendant is advised that by pleading guilty to this charge, they will be giving up their right to possess firearms, because that is what the federal law requires. And we do not want to be in a position where this is appealed and the Supreme Court vacates our plea deals or plea statements because the defendant has not been advised of their rights. So I ask for adoption. Thank you.
Further remarks? Senator Wagoner.
Thank you, Mr. President. Rising in support of the amendment and in awe, once again, of Senator Dhingra's legal acumen. She quite rightly caught this early on, and we believe that it just provides transparency and it is factual. Hoping for everyone to support it.
There are no further remarks. The question before the Senate is adoption of Senate Amendment number 0157. Remote members are reminded to please raise your hand to indicate your vote. All those in favor of the amendment signify by saying aye. Aye. Opposed, no. The ayes have it. The amendment is adopted. Further amendments, amendment number 0158, the Secretary will read.
On page 10, line 27, after 8, insert, once the diagnostic and treatment, section D.
Senator Dhingra.
Thank you, Mr. President. I move adoption of Amendment 0158.
Senator Dhingra moves adoption of amendment number 0158. Remarks, Senator Dhingra.
Thank you, Mr. President. So after the court does the colloquy and confirms that the plea is made knowingly, voluntarily, and intelligently, and then the court accepts the plea, at the time of sentencing, they then have to do an order of ineligibility to possess a firearm. And that is what this amendment does. It ensures that the court then does the notice of ineligibility to possess a firearm. I know people talk about due process a lot, but this is literally what we mean when we say due process. And so I would ask for a yes vote on this amendment.
Further remarks, Senator Wagoner.
Mr. President, we also support this amendment.
If there are no further remarks, question before the Senate is adoption of Senate Amendment number 0158. Remote members are advised to please raise your hand to indicate your vote. All those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. The amendment is adopted. Further amendments, amendment number 0163, the Secretary will read.
On page 11, line 7, after attorney, strike
Last
may,
line.
insert shall.
Senator Hawkins.
Thank you, Mr. President. I move adoption of Amendment 0163.
Senator Hawkins moves adoption of amendment number 0163. Remarks, Senator Hawkins.
Thank you, Mr. President, and good evening. This amendment deals with the pretrial diversion portion of the striking amendment. And I will say one of the things I do like about this striking amendment, in my opinion, Mr. President, is it does appear to strike a good balance between compassion and accountability. However, there appears to me to be a pretty significant inconsistency between prosecutorial discretion and judicial discretion in the striking amendment. And I can point this out to you, Mr. President, if you'd grant me permission to read from the striking amendment.
Please proceed.
Thank you, Mr. President. So on page 11 of the striking amendment, and forgive me, but there's a lot of items in a series related to the pretrial diversion, but it does say, if it appears to the prosecuting attorney that the defendant is not substantially complying with the recommended treatment of services, that the defendant is convicted of an offense that reflects the defendant's propensity for violence, that the defendant is charged with a subsequent violation, or that the defendant is convicted of a felony, the prosecuting attorney may make a motion for termination of pretrial diversion. And so to me, I think there's a potential for people to just sort of cycle through, even though they're not substantially complying with the recommended treatment and all these other things. And then in that same section of the striker, Mr. President, there is a section related to judicial discretion. If the defendant has successfully completed pretrial diversion, including meaningful engagement with recommended treatment or services, at the end of that period, the criminal possession charge or charges must be dismissed. And so to me, that is an inconsistency. And I think there is a potential, depending on the prosecutor, to just let people cycle through and not really get the full ramifications of their actions and ultimately not get better. So this amendment, Mr. President, simply would change the word may and include the word shall. And I do recognize I might be a little bit unmatched, Mr. President, because I'm arguing to take away prosecutorial discretion, and I'm going to be debating this amendment with a seasoned prosecutor. But I urge the body's support for this amendment. Thank you.
Senator Peterson.
Well, thank you very much, Mr. President. I'm very sorry to have to move to suspend Rule 15 so that we can continue working past 10 p.m.
Senator Peterson moves that Rule 15 be suspended. Hearing no objection, so ordered. Senator Dhingra.
Thank you, Mr. President. I promised Senator Hawkins I'd be smiling before I started. I'll be smiling throughout while I speak, and I'll be smiling at the end. That was our deal. I unfortunately rise in opposition to this amendment. We'll have an opportunity to discuss judicial discretion. Prosecutorial discretion encompasses all aspects of a crime. The prosecutor decides whether they're going to file a charge. They decide whether they're going to provide or grant immunity. They decide whether to allow a plea and what all is part of that plea deal. Our prosecutors are independently elected officials, and while I would love to tell some of them how to do their job, this amendment is clearly imposing upon their constitutional responsibilities. And I'm going to ask for a no vote. And I would like to point out to Senator Hawkins, I was smiling the entire time through, Senator Hawkins.
There are no further remarks. Question before the Senate is the motion to adopt amendment number 0163. Remote members are asked to please raise their hand and indicate their vote. All those in favor of the amendment signify by saying aye. Opposed, no. Noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0159, the Secretary shall read.
On page 11, line 17, after including, strike meaningful engagement and insert substantial compliance.
Senator Robinson.
Thank you, Mr. President. I move adoption of amendment number 159.
Senator Robinson moves adoption of amendment number 0159. Remarks, Senator Robinson.
Thank you, Mr. President. This amendment literally is correcting a drafting error. It's late, I can't talk. These words occur other places in the striking amendment. Staff missed it in this one line, and this amendment is correcting that. Please vote yes.
There are no further remarks. Question before the Senate is adoption of Senate Amendment number 0159. As many are in favor will signify by saying aye. Opposed, no. The ayes have it. The motion is carried. Further amendments, amendment number 0164, the Secretary will read.
On page 12, at the beginning of line 7.
Last line.
Internal references accordingly.
Senator Padden.
Thank you very much, Mr. President. I move that Amendment 0164 be adopted.
Senator Padden moves adoption of Amendment 0164. Remarks, Senator Padden.
Thank you, Mr. President. We had a special day in Law and Justice where we heard 4 bills really dealing with the Blake decision and various solutions to them. I had a bill, and the good senator from the 32nd, good senator from the 38th, and our chair from the 45th. So this was not in my bill, or this concept. It was in a bill by the good gentleman from the 32nd District, and simply requires the court to sentence individuals convicted of possession who refuse to comply with treatment as a condition of probation to no less than 45 days in jail, and secondly would require the court to reinstate 45 days of an individual's suspended sentence if the individual, while on probation, willfully abandons or demonstrates a consistent failure to comply with treatment. I mean, this is a reasonable amount of jail time, and sometimes with folks in jail, depending on stuff, that's actually where they get rid of their addiction. Well, that's not necessarily the purpose of this, but it is something that may happen, And again, it shows some accountability to comply with the court orders. And we are, in this legislation, doing a lot, an awful lot for treatment. There already is a lot in the current law, but we are expanding on that. And I think we need a little balance. Treatment's good, but let's also have some accountability. And so this is, I think, a worthy amendment. And the idea, as I said, came originally from the gentleman from the 32nd District. Thank you.
Further remarks, Senator Dhingra.
Thank you, Mr. President. I stand in opposition to this amendment. You know, I think we all try to be data-driven, evidence-based, and there is absolutely no evidence or data to suggest that 45 days has any magical meaning. It's simply a time that someone thought sounds good. It is not the amount of time it takes someone to get over drugs. It's not the time it takes someone to stabilize. There's no scientific basis for 45 days. Unfortunately, what 45 days does do is it ensures someone loses their housing because they haven't paid rent. 30 days are up, they haven't paid their rent. Going over 30 days also ensures that they've lost their benefits, because guess what happens? After 30 days, the benefits get cut off. And so with the 45 days, what you are putting into statute is that when that person gets released, because they're not magically cured at this point in time, Mr. President, they're still a drug addict. What happens is this person no longer has housing, this person no longer has access to benefits. So you are actually making their situation worse. You're actually making it worse for public safety, because now they truly have hit rock bottom, because anything they had before is now completely gone. This is extremely counterproductive to any data or evidence-based information we have on how to deal with addiction. We've also had a wonderful bill this year where we had a really long discussion and conversation about what's going on with a graduated reentry program. What we had found over the last few years is that overdose fatalities have been very high. And a few of us have been reading those reports. Turns out, when you release someone from a jail prison setting, their chances of overdosing at that point in time are extremely high. So what you accomplish when you mandate jail time is an increase in overdose deaths. After longer than 30 days, they no longer have access to the housing, and their benefits have been cut off. I'm going to ask for a no vote on this amendment. Thank you.
Further remarks, Senator Padden.
Thank you, Mr. President. Obviously, there's quite a philosophical chasm here. I mean, what about the victims? What about the victims that have suffered because of the drug addict that commits crime to feed the habit? We've had an explosion of drug gangs throughout the state. They, as I've mentioned before, are tagging and making their mark in rural areas. But that's how they pay for these drugs. They commit crime. And as far as overdoses, they've been accelerating under our current policy at a tremendous rate. And to me, the argument that the gentlelady made really almost was, let's not have any punishment at all, at least as far as physical confinement. I mean, I just think that is counterproductive. And I know she sincerely believes what she believes, and I believe the opposite, and I think you got to have some accountability, or you're not going to get compliance with treatment. I mean, right now, folks are supposed to go get treatment if they're arrested for possession of a hard drug. How often is that really happening? In my opinion, very little, but we really don't know because the law doesn't work. So we need something that works, and I think we need a balance between accountability and treatment, and this amendment provides it at somewhat of a modest effort. I think it was a good idea that came from the gentleman from the 32nd District. Thank you.
Further remarks, Senator Dhingra.
Thank you, Mr. President. I want to be very, very clear. This is only about simple possession. Any crime that occurs is in addition to. We have criminal charges, robbery, burglary, assault. They're all independently charged and prosecuted. We're not talking about crimes that occur in addition to drug possession. We're talking only about simple possession. So I want to be very clear. If there are victims on there, those crimes absolutely are prosecuted and should be prosecuted. None of those are being changed. There's no alterations to any other criminal activity. This is only about simple possession.
There are no further remarks. The question before the Senate is adoption of amendment number 0164. The President reminds remote members to please raise your hand to indicate your vote. All those in favor of the amendment signify by saying aye. Opposed, no. No. Noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0156. The Secretary will read.
Beginning on page 14, line 3, strike all of subsection 9, renumber the remaining subsections consecutively, and correct any internal references accordingly.
Senator Wynn.
Thank you so much, Mr. President. I'd like to move adoption of Amendment 0156.
Senator Wynn moves adoption of amendment number 0156. Remarks, Senator Wynn.
Thank you so much, Mr. President. And very similar to the previous amendment, the reason why I offered this is that if we want to hold people accountable or if we want to actually help people. And I think there's been research in Washington State, and we've seen through history in our judicial system that coercive treatment doesn't necessarily give us the best outcomes, nor does it actually help the folks that we are trying to help. And oftentimes when we have these types of programs where folks have a definite time and then they move off, the outcomes don't become better, and oftentimes they'll overdose as well. What I will say is that I do appreciate that this body is able to have a very serious and thoughtful discussion. I think we all care about our communities. We all want to make sure that we have public safety for those who are involved. And in these times, as we try to figure out what that looks like, it becomes an issue of understanding our different perspectives as well. So what I'll say is that I believe that we're here to do the right things. I believe that this amendment actually doesn't help make us any safer, nor does it protect the people that we're trying to save. And we're choosing, in this case, a policy that is rooted more so in emotion than it is in data. But at the same time, I understand that this is what the debate looks like. So with that, Mr. President, I'd like to withdraw this amendment.
Hearing no objection, amendment number 0156 is withdrawn. Further amendments, 0166, the Secretary will read.
On page 14, line 16, after third, insert or subsequent. On page 36, after line 11, insert the following. New section, section 32.
Last line.
Effective date and insert effective dates.
Senator Mullet.
Thank you, Mr. President. I move adoption of Amendment 166.
Senator Mullet moves adoption of amendment number 0166. Remarks, Senator Mullet.
Thank you, Mr. President. As I was touring our state during the interim, visiting capital budget sites, I met with a variety of people in the public safety space and realized the challenges our crime lab is having in getting, evidence returned back in a timely manner. So in Ways and Means, I did offer an amendment to speed up that turnaround time to 45 days, but I made the mistake in that amendment of having that start in July of this year, when the agreement with State Patrol was if we give them the bodies, they can get rid of the backlog, and then starting in January of 25, we can get our crime lab evidence back in 45 days. Right now, we're experiencing 6 or 9 month delays often. So I encourage everyone to support this amendment. We are funding the additional bodies for State Patrol within this bill, and we will get better crime lab turnaround in the future. It's just not going to happen right away. Thank you.
Further remarks? There are no further remarks. The question before the Senate is the adoption of Senate Amendment Number 0166. Remote members are reminded to please raise your hand to indicate your vote. All those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. The amendment is adopted. Question before the body is the striking amendment as amended. Remarks, Senator Robinson.
Thank you, Mr. President. I'll save my remarks for final passage.
Further remarks? Senator Robinson? Excuse me. The question before the Senate is the adoption of striking amendment 0154 as amended. Remote members are reminded to please raise your hand to indicate your vote. All those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. The striking amendment is adopted. Now, Senator Robinson.
Thank you, Mr. President. I move that the rules be suspended, that engrossed second substitute Senate Bill 5536 be advanced to third reading, the second reading considered the third, and the bill be placed on final passage.
Senator Robinson has moved that the rules be suspended, that engrossed second substitute Senate Bill 5536 be advanced third reading, second reading considered the third, and the bill be placed in final passage. Hearing no objection, so ordered. Engrossed second substitute Senate Bill 5536 on third reading and final passage. Remarks, Senator Robinson.
Thank you, Mr. President. This is a very challenging public policy to talk about, to think about, and to try to solve. And in fact, there probably is not a single or a perfect solution to the problem that's before us. We, in fact, challenged ourselves as a body 2 years ago when we passed a bill with a sunset date on it. And here we are today needing to follow up on that challenge that we gave ourselves. It's now up to us to bring a policy to our communities that can work for the people who need it. I believe that the bill before us strikes a good balance. I don't know if it's exactly right, but a balance between compassion for people suffering from addiction and accountability. My goal throughout this process is to provide options for diversion and treatment and services, and this bill offers many opportunities for that throughout the process for anyone who is found with in possession of drugs. At the same time, I've heard loud and clear that our communities want accountability. They want tools to be able to reinforce messages about public safety, and I believe that the bill before us will give that to our communities as well. I urge your support of this bill tonight. This is not the last. This bill will continue to move through the process, and I'm sure it will change. There will be more ideas, thoughts, good thinking that go into this before we end our time here in 2023. But for tonight, I hope that we can move this bill off the floor. Thank you.
Further remarks, Senator Padden.
Thank you very much, Mr. President. I do want to thank the gentlelady from the 38th District, and I guess I would agree that this bill is better than what our current policy is, which, as I indicated earlier, has not worked at all. But I really believe that it doesn't go far enough in balancing the accountability with the treatment. It makes some efforts, and I'm afraid as to what may happen to weaken this legislation as it makes its process through its legislative journey. Again, I think you've got to have what law enforcement has said, and in order to enhance public safety, you've got to have accountability, and you've got to have some leverage to get people into treatment. And we weren't even able to adopt the amendment on fentanyl, which is exploding, to consider that a felony, to have some balance. And again, that's what it was before on February 24th, 2001. and the Supreme Court did nothing to call into question the classification of that as a felony, which previous legislators had affirmed for years and years and years. It was used by those that want really decriminalization to get de facto decriminalization, and this is certainly preferable to that. But again, I will be a no. It doesn't go far enough to get the leverage, to get the accountability, so I'm urging a no vote.
Further remarks? Senator Mullet.
Thank you, Mr. President. I stand in support of this bill. I want to commend Senator Robinson on her work on this issue, and I think it's important to compare and contrast what's in the bill in front of us today versus what I think a lot of us lived with in the 80s and the 90s in terms of the war on drugs. In the war on drugs, I think what we had was people just getting arrested and putting in jail. There was zero attempt at trying to get people treatment for their substance abuse addiction. We learned from our mistakes. We realized that that was not a good public policy. And what we have in this bill in front of us today is the first time you are arrested. We had nonpartisan staff explain this to our caucus this evening. You actually have 4 different attempts to get into treatment, 4 different attempts before you get into treatment. And if none of those work, the judge has full discretion on that first arrest around whether or not you actually spend a single day in jail. You may not spend any time in jail on the very first arrest. And on round 2, you have anywhere from another 1 to 4 attempts at getting into treatment. This is a treatment-focused solution to the drug challenges facing the residents of Washington State. We are going to invest tens to hundreds of millions of dollars, Mr. President, in trying to finally get in front of the substance abuse challenges that we are witnessing in our state, where we are seeing people unfortunately dying at a rate that is not good for any of the families that we here represent. And I am very proud that Senator Robinson, I think, has found a middle ground proposal on a bill that is focused first on getting people into treatment, but does have accountability, saying after several attempts, if for whatever reason they are refusing treatment, there are going to be consequences. Those consequences aren't there because we want people to actually spend any time behind bars. Those consequences are there because there is evidence we feel that indicates those consequences will actually increase the likelihood of someone actually finishing their treatment regime. And that is the end goal, Mr. President. We want more people to actually finish their treatment. The challenge in the current system is, for one, we don't have enough treatment facilities. We are fixing that in this bill. 2, after those treatment facilities are online, our hope is that we will make sure more Washington residents are actually getting the treatment they need all the way to the finish line. I encourage everyone's support this evening.
Further remarks? Senator Wagoner.
Thank you, Mr. President. And my remarks are going to be remarkably similar to Senator Robinson's. This is a complicated and divisive issue, but one that we had to face. And I'm proud of this entire body that we're facing it tonight. I wish we would have passed a bill like this 2 years ago, but we didn't. But tonight, as much time as this took and as much angst as it has provided on both sides of the aisle, we reached common ground, and I'm proud of that. I want to thank Senator Robinson for working in good faith to find that common ground and doing the work that people of Washington expect us to do when we have hard issues like this. Work together and find some space in the middle. As Senator Mullet mentioned, this bill gives chances. It gives first chances, second chances, and third chances for people to correct their ways and get back into life and be productive citizens and get back to their families. That's probably the most important thing that it does. It also gives law enforcement tools to help those people along the path. And I believe it's going to give back security in our neighborhoods and our cities that we haven't seen for a long time. I would say that's my belief, and we're going to find out. You may remember Aesop's fables, I don't know. There was one fable of the raven and the pitcher, and the moral of that fable was necessity is the mother of invention. In this case, necessity and our duty to the people of Washington State was the mother of compromise. And how do you know when you've compromised well? Well, on this side of the aisle, I can tell you nobody is jumping for joy tonight to support this bill because many over here think we gave up too much. I believe it's an analogous situation on the other side. Some believe they gave up too much. And that is how I know we got it right tonight. I'll vote yes.
Further remarks, Senator Trudeau.
Thank you so much, Mr. President. And I very much appreciate what's been said on this floor. I appreciate the opportunity to compromise, and I don't mean to ruin the kumbaya moment that we're having, but I wanted an opportunity to explain why I'm actually going to be voting no on this legislation. I believe in accountability. I voted on a bill that was not decrim coming out of committee. I believe that when someone commits a crime, they should be held accountable for that crime. But I also know what addiction looks like, Mr. President. And I also know that while this is a far stretch from some of the policies that came through on the war on drugs, what the war on drugs did do was it imposed additional penalties, including jail and prison time, on populations that are now reflected disproportionately in our systems. That's what it did. It didn't help people heal. It didn't help them get better, because that's not what those institutions are designed to do. And if you've ever known somebody that is suffering from drug addiction, Mr. President, that's not, when they are in the throes of their addiction, that is not who they are. It controls and consumes them in a way that if simply putting them in jail for an arbitrary amount of time was going to resolve that, if knowing that criminal penalties were being offered wasn't a deterrent then, it's not going to be a deterrent now, and people are going to come out sick and sicker. And what we do know, and what the data does show, is that when people are released is when they are more susceptible to overdose and death. And for me, that is a bridge too far. I cannot vote for something that sounds good. It sounds great to say, great, if they don't go to treatment, send them to jail. But it hasn't been ever proven to work. And I've watched people in my life suffer through an addiction that consumes their personality, that makes them make choices that they would never make if they were clean and sober. And I've watched some of them spend time in jail and prison systems, and it didn't make them better. I am always going to say accountability is key. People have heard me say, let's collect data, let's look at data, let's examine the facts on the ground, and let's make an informed decision. I do not believe that's what we're doing today, and I believe there are deep issues with what we're passing off the floor. And I appreciate the work of the prime sponsor. My goodness, I mean, this is, I will say it's doing the Lord's work to take this issue on. And I thank her deeply, and I thank everybody who's engaged. But there is a difference between doing good and sounding good. And I don't believe that this is the good that we think it is. And that is why I'm going to vote no on this bill. And I just want to thank everything that's been said and everybody for their work on it, but I just wanted to stand up and say my piece, and I thank you, Mr. President.
Further remarks, Senator Nguyen.
Thank you, Mr. President. Senator Salomon would like to speak.
Senator Salomon, you are recognized.
Thank you, Mr. President. The good gentleman from the 5th District was right. The 1980s approach of a war on drugs did not work. It failed. 2 years ago, we took a different approach. And what we've seen over the last couple of years is a rise, in part because of that approach, not fully, in drug use, public drug use, overdose deaths, and so on. In speaking with my community members in the areas that I represent, and speaking with the police, prosecutors, etc., they found that there's essentially no way to file the misdemeanor charges that are technically available to them. Because they need to show that there's been 2 referrals, they can't make the stops or demand the ID to figure out if a user has had 2 referrals. It just doesn't work. So we had a situation of de facto decriminalization. This bill is a very interesting and I think a very exciting treatment forward approach that has accountability built in. I think it takes the best of the different systems. If you are caught possessing drugs under this bill, the police may refer you before any charges are ever filed to treatment program, to the lead program. If that doesn't happen and charges are filed, a pretrial diversion may be offered. If you complete the pretrial diversion, your case is dismissed. If you fail the pretrial diversion, you proceed with the criminal charge, the gross misdemeanor. If the judge finds you guilty of the gross misdemeanor, this is the only criminal law that I'm aware of that does not allow the judge to impose jail time. I'll repeat that. If you're found guilty under this bill, the judge would not be allowed to give you jail time. The only thing that you could be sentenced to is a substance use disorder treatment program. We just want you to do treatment. Want people to get better. If the treatment is completed, the conviction is vacated, overturned off your record as if you've never been convicted. There are so many off-ramps. If that doesn't happen, if the person willfully abandons or fails to complete treatment or consistently demonstrates failure to complete treatment, the judge on your first offense can then revoke that probation and give you jail time from 0 days to a year. Then repeat all that, your second offense, with all those other treatment options all over again. The judge must revoke 21 days of jail. And then the third offense, 45 days of jail, and for the fourth, fifth, sixth, etc., as a minimum. That's not jail up front, it's just for not doing treatment. It builds in accountability in the back end. And there are innumerable ways to do treatment. This bill is an amalgamation of many ideas. There's also from the SURSAC committee, Substance Use and Recovery Committee, took a look at how can we support people coming out of addiction. And we took many of those recommendations on harm reduction, increasing treatment, put that into the bill. So there's a whole host of ideas in the bill. I think it's taken ideas from across the political spectrum and creatively wove them in. I do think this gives us hope to finally crack the code on the problems that we see out in our communities everywhere. And I think we should move forward with this. This has been a very, very difficult debate, emotional debate. I guess you could say divisive, but I think this bill is actually unifying because it takes ideas from so many different sectors, from police to the recovery community and everything in between, and interweaves it in a tapestry that I think is going to work for our community. So I urge your support of the bill. Thank you very much.
Further remarks? Senator Dhingra.
Thank you, Mr. President. I always like to stand up and clearly articulate what's written in the bill, what the impacts of the bill are, because I think we need to be grounded in reality. The reality is, people do not commit crimes consecutively. Someone who's addicted to substance uses doesn't get caught by police, wait for hopefully 45 days, maybe longer, until the crime lab's done its work, go through the system, then relapse 6-8 months later. That's not the way addiction works. In a real life scenario, what you're going to have is someone who is arrested. They're going to be arrested with multiple charges because that's the way addiction works. You're going to have an individual that has 4 or 5 different charges. Because we're dealing with district courts and municipal courts, it's going to be in a wide array of different jurisdictions. We are going to have challenges with jurisdictions coordinating with each other. We're going to have challenges with multiple counts, with multiple criminal charges, thefts, robberies, assaults. That's the way life works. So I want to be very, very clear that what is laid out is not the way things work in the criminal justice system. People don't wait periods of time to commit a crime. They don't wait until they have their next offense. Most of this criminal activity happens in pockets. And it's really fascinating as a prosecutor when you get referrals in from law enforcement. Because while you get these referrals in, you don't file them right away. Normally there's a backlog, even though people try not to have backlogs. And you will see then that this one individual who is referred for a crime, you'll get a couple of cases on them, or there'll be a city case. And when you take a look, there are lots of interesting things you can find out about individuals, because crimes occur in pockets, not consecutively. There's a really fascinating case, and it's always stayed with me. It was about this woman who you would see stealing a motor vehicle, drug possession case. You'll see another something happen. And you know, you take a look at all those cases, you file those cases, and then we saw that while she was on probation through treatment court, she would do great. She would actually comply. She got her kids back. She got set up with a job and with a place to live. And then 5 years later, I see her in the criminal justice system again. And I had thought that was a success story. We took a whole bunch of her cases, got her through the treatment courts, she got her life back together. Turns out, she would engage in criminal activity because when her boyfriend got out of jail or prison, he would get her addicted to drugs. And at that time, there would be a whole bunch of criminal activity that occurs because of that. It was more complicated because there was domestic violence, and it became extremely complicated. That's life. That's the way the criminal justice system works. It does not work on one person who commits one crime, is given options for treatment, then the second crime occurs, and you go through it. So I want everyone in this body to be very, very aware. This is not how it's going to play out in reality.
Further remarks, Senator Nobles.
Thank you, Mr. President. I have spent hours today listening to my colleagues and trying to understand this legislation, and it is very challenging to understand, and I have very brilliant colleagues. All of them that I trust in some way, shape, or form, even if those are not all the same ways. And tonight there were words describing this bill such as exciting and unifying. And I think for me today, discussing this bill has been very traumatizing. And I'm really sleepy because my bedtime is 9 o'clock. And so I'm gonna try not to just have a meltdown here. But listening to the conversation, it has just made me think about the reality of, you know, some of the stories we've talked about. And to have a parent that still to this day, 30 plus years, struggles with a substance use disorder, and to know that the war on crime did not work. And in the 80s and 90s, I had to watch my parent sit in jail, face prison, and here we are decades later, and they're still struggling with the substance use disorder. Throwing the book at my mother was not the solution for her ever. It landed our family in shelters. It landed my siblings and I in foster care. And my mother still struggles with her substance use disorder. And so when I listen to these stories and the ways that we want to wag our finger at someone and think that that's gonna bring them healing and bring us justice, it's just not the case or scenario for everyone. And I'm sure there will be cases where this legislation will have a positive impact, I'm sure. But I just have a real life story where I just know and understand that I wanna be a more compassionate leader, a more understanding leader. I want to be a leader that's going to look at real solutions that help individuals who are going to struggle with substance use disorders. And when I have seen my mother shine and really make progress, it's when she's been able to live in a clean and sober house, when she's been able to get her behavioral health support, and when she's been able to be treated for her substance use disorder. And I've heard people use past tense, you know, they've loved or watched or helped, but I love, I watch, I help, I talk to and navigate with my mom on a daily basis as she walks through her substance use disorder. And so I'm a no on this legislation. And again, I'm sure my colleagues mean well. And I'm sure if this passes out the legislature, there may be many individuals that benefit positively because maybe they'll get the help that they need. But I just know that my vote will be for folks who criminalizing their behavior, not giving them the help that they need. It's not going to help them to move forward, and it's going to destroy more families. And I don't want to be a vote to see more families go through what I had to go through. And I'm crying not just from the trauma of today, but I'm crying just because I'm tired. And I, would love to go home, but this is important legislation. And I wanted to lend my voice to the issue and just real stories and real people from not the past, but the present. And so I love my mom, even with all her struggles, even with all the things that she put us through. And I hope that she continues to lean into the things that have helped her. And as many times as we need to send her to rehab, or as many times she walks into rehab, as many times as she finds herself unhoused, I will stand by her. And I will never criminalize her because she has an illness. And so again, I vote no, and blessings to my colleagues, however they choose to vote tonight, Mr. President. But I hope that we remain compassionate and that we are striving towards real solutions for people in our community who are really struggling. Thank you.
Further remarks? Senator Frame.
Thank you, Mr. President. I'm also rising to share that I will be voting no on this legislation today. And it's hard to be more articulate than some of my brilliant colleagues who have already spoken to their no votes. I am not a lawyer. I am not somebody who's worked in the prosecutorial system. I'm just a legislator with a lot of lived experience who has spent the last 7 years on the other side of the rotunda trying to fix our criminal legal system. As you heard Senator Trudeau articulate very clearly the data, and we all voted on a bill from Senator Gildon earlier in this session on this exact topic of when people leave incarceration, that is the highest risk time for them to overdose and die. We all voted on that bill together. So we know the data that Senator Trudeau articulated on this floor moments ago is true. At least that's what I would think is happening when we voted for that bill. I'm troubled by a couple of things about this legislation. One, we had in the underlying law discretion for our judges to reimpose up to 364 days of jail time if, based on the circumstances of the case before them, they believed incarcerating somebody was actually the right call given the circumstances of the case. That was there. But we've gone the next step and then appointed ourselves prosecutor, judge, and made ourselves way beyond the scope of our practice here and said, we are picking the days. We're saying 21 days. We're saying 45 days. Folks, these are arbitrary numbers that we just made up. And I'm disappointed, Mr. President, because I was just on the other side of the rotunda, and I watched our colleagues on both sides of the aisle have a very courageous conversation and acknowledging that the system that we have on the criminal legal system, different topic, but related, a courageous conversation about what isn't working and stop allowing ourselves the false sense of security in the things that we have in law today because we know they're not working. In that case, it was about interrupting cycles of violence for childhood sexual abuse. I watched a courageous conversation tonight on the other side of the rotunda. And what I am watching right now is us knowingly putting into statute something that's not based on fact, that's not based on data, and in fact, we know may result in people dying. I don't think people dying is the right solution to this. And I'm particularly troubled when we know who dies. We know that it is disproportionately our Black and brown neighbors that are suffering these addictions, that are overly incarcerated, and those are the folks who are going to die. And I am so sorry, I can't see any of my colleagues behind me. I imagine that it's triggering, and traumatizing. We just heard that from Senator Nobles. But I feel compelled to speak the truth about what this is. It is something that we can point to, that we did something. It feels and sounds good, perhaps. I do not think it is going to work. As Senator Dhingra said from her prosecutorial background, I can say from my lived experience as somebody in a family with intergenerational abuse, trauma, etc. I do not think it will work. I think people are going to die. I am deeply uncomfortable that that is the policy we are sending out of this body, and I ask for your no vote, Mr. President.
Further remarks, Senator Hasagawa.
Thank you, Mr. President. So I think it's important to think back a couple of years when we first got put into this position with the Supreme Court decision on Blake. At that point in time, the world was in the middle of a revolution, basically, and we were having an epiphany as a society about the disparities that this society has imposed upon Black African-American descendants primarily, but all other brown ethnicities, brothers and sisters as well. There was an epiphany going on throughout society. And during that time, when the Blake decision came down, we scrambled to try and implement some of our newfound wisdom and put it into a bill which, at that time, some of us didn't think would work. And I voted against it then, and it turns out there were problems with that. So here we are today trying to fix some of those things that didn't work from a couple of years ago. That's what I thought we were doing, at least. But this bill goes quite a ways beyond that. It's taken a different paradigm altogether. So when we were in the Ways and Means Committee, we had a pretty good discussion about this bill. And there was a couple of questions about the level of, the main point that was brought out is that in order for the treatment to be effective, that person has to want to go into that treatment as soon as possible. It didn't matter what the level of offense was driving that decision, whether it was simple possession or simple misdemeanor, gross misdemeanor, felony even for that matter. That person had, the whole point was that there was something there to drive that decision and get that person to make that decision as soon as possible. That shortness of time frame and the immediacy was what makes it effective. On the other hand, in thinking about once successfully completing treatment, that person needs to have a job to go to build a sound, solid foundation for a life after treatment. The level of offense that we have chosen now, gross misdemeanor, given that there's no science, because I asked in Ways and Means, is there any studies that shows the level of offense having any effect on that decision-making process? The answer was no. And if the level of offense is higher, how does that affect the employer, future employer's decision to want to hire that person previously? Because that's going to be crucial to ultimate success. No science on that. But the feeling is the higher the level, of course, the more problem of getting hired afterwards. So we're doing all of this without any scientific basis. And I think we've lost sight of the fact that a couple of things. Senator Dhingra pointed out, we are talking about simple possession. We're not talking about all the ancillary things that go on, which are still prosecutable. We're just talking about simple possession and trying to get the person into treatment. We're talking about a behavioral health issue. We're not talking about necessarily criminals. We're talking about people who are stuck in this life cycle of addiction and have not been able to get their way out of it. Getting them into treatment. It's not about so much the penalties afterwards. So in looking at all of this and in looking at the failed war on drugs, or actually in some people's minds it may have been successful, depending on your view, but it sure disparately impacted communities of color, for sure. And we're trying to figure out how we can make reparations for that and create a society that's healthy and views with compassion and looks at the problem as a behavioral health issue, not a criminal issue. So with all these considerations, because I know in my district, there's a lot of people who are blaming all the social ills of the world on Blake. Come on, we're talking about simple possession. You know, they're talking, and I understand the small businesses in the areas struggle with all of the apparent ramifications and consequences they're seeing on the street there, but that ain't a result of Blake. I think we need to really take a look at how we're dealing with this problem from a behavioral health perspective and a recovery perspective. So at this point, one other thing I should probably mention, which may or may not be viewed with welcome here, but in the Ways and Means Committee, when we considered this and we passed it out of the committee, none of the people of color on that committee voted to pass this bill out of committee. So I think it's a point of note to be taken up by this entire body as we consider voting on this bill. Thank you, Mr. President.
If there are no further remarks, the question before the Senator Wellman.
Thank you, Mr. President. This has been a very troubling evening. But the discussion about Blake has been, for me, a very troubling, from taking it from last session and thinking about the fact that we do need a solution. We do need something to move forward. It's a process. The process has been troubling all along, and I have heard many things that have caused me really to change my mind, certainly about what I'm looking at. And as I've shared with my caucus, I am not a lawyer. We listened to lengthy discussions, and I really wasn't sure what I was being told about anything until we heard from members of our caucus about how it would affect people that they know. And that was extremely troubling. I also know, Mr. President, that this is, as I said, this is a process that, if this bill goes forward, doesn't stop here. And that is the only thing that gives me hope. I sit here at the end of the alphabet, or towards the end of the alphabet, and I don't have the luxury of taking a no vote in my mind that I would ordinarily take if I was at the beginning of the alphabet. I feel like we need a solution. We need to keep something working. It is not, I don't feel I have the indulgence of taking a no vote. I will be voting yes and hoping that we can keep something going and get to a more just and workable solution, taking into account the very true stories, the very real accounts that we have heard this evening. Thank you.
If there are no further remarks, the question before the Senate is final passage of engrossed second substitute Senate Bill 5536. The Secretary will call the roll.
Billig. Binky. Braun. Cleveland. Conway. Dhingra. Dozier. Fortunato. Frame. Gildon. Hasagawa. Hawkins. Holy. Hunt. Kaufman. Kaiser. King. Cooterer.
No.
Leas. Lovelet. Lovick. McEwen Drew. McEwen Jim. McEwen Jim. Mullet. Mazzol. Wen. Nobles. Padden. Peterson. Randall. Rivers.
No.
Robinson. Rolfus. Saldana. Salomon.
Aye.
Chesler. Shoemake. Short. Short. Stanford. Torres. Trudeau. Valdez. Vandeweghe. Wagoner. Warnick. Wellman. Wilson Clare. Wilson Jeff. Wilson Jeff. Wilson Linda.
Senator McCune, how do you vote? Senator McCune votes no. Senator Short, how do you vote? Senator Short votes no.
Mr. President, there are 27 yea, 22 nay.
Senator Torres? Senator Torres changes her vote from no to aye.
Mr. President, there are 28 yea, 21 nay.
Having received a constitutional majority, engrossed second substitute Senate Bill 5536 is declared passed.